just for the moment. All right, good afternoon, everybody. Did you hear? I'm going to try to fix the echo. Just a second. Now, okay. All right, that should work now. Good afternoon, everybody, and welcome to the fourth annual Americans for Prosperity Foundation Sunshine Week Symposium. My name is Ryan Mulvey, and I'm a policy counsel here at AFP Foundation, and one of our resident transparency guys. I do our FOIA litigation. I'm also on the side as the president of the American Society of Access Professionals, the requesting community, and for the most part, the membership are federal information specialists, FOIA attorneys, and other FOIA officers. This year for the symposium, we've done something a little bit different, where we have decided to bring together voices from the right of center community to discuss transparency issues in a broad way, to include not just freedom of information laws, but also open government and transparency generally. I hope you've had a chance to read through the essays that we've been publishing throughout the week. The last of those by Thomas Kimbrell went up just a couple of hours ago. I think the contributions were all thought-provoking and excellent. And part of this webinar is to give each of the authors an opportunity to briefly discuss their contribution or to respond to other pieces that have been published, or to just speak generally about something else related to Sunshine Week. And then to have a conversation and even to answer questions from any of our audience and our readers. Very quickly, since we have a lot of panelists, I'm just going to introduce each of them in the order that they'll speak, which was the order of publication of their essays. And then we'll start a round of about 5 minutes for each speaker. Our first speaker is Braden Busick from the Southeastern Legal Foundation, where he serves as Vice President of Litigation. Kevin Schmidt is second. He's our Director of Investigations at AFP Foundation. Joe Bishop-Henchman is Executive Vice President at the National Taxpayers Union Foundation. Alan Blutstein is founder and the principal at FOIA Advisor. Andrew Blackburn is Program Manager at the Regulatory Studies Project at the Mercatus Center at George Mason. Greg Brooks is President of the Better Cities Project. Liam Gallagher is Legislative Director for Americans for Prosperity, Kentucky. And last but not least, Thomas Kimbrell, who's an investigative analyst for AFP Foundation on its legal and judicial policy team. So with all those introductions out of the way, let's jump right to it. And Braden, the floor is yours.
Thanks very much. Before I begin, if I sound a little garbled, it's because I had a root canal this morning. So everybody, please forgive me. I think I'm capable of soldiering on, though, but I appreciate everyone's patience with me. I'll begin by saying something rather obvious, and that's that if you feel like a lot of our national debates don't sound like they're going anywhere very fast, you're certainly not alone. Study after study show that Americans are frustrated with the tenor of our debate, and probably nowhere is this more in display than when it comes to arguments about what's going on in kids' schools. This has, of course, been the subject of intense feelings over the last couple of years, starting and continuing through COVID, and it doesn't show any signs of abating. And Americans of all stripes have now been routinely treated to the spectacle on the news of shouting frustrated parents at school board meetings, getting their mics cut off, occasionally being let out by security, and in some cases, even resulting in arrest. The conversation often centers around what actually is being taught, with two parties talking past each other, with one party making a claim that something is being taught and somebody making a claim that it isn't. So naturally, the facts of this debate lay right at the heart of it. And we found through our work that that's really not accidental. part of the reason why this debate grows so stale is because parents are unable to access a lot of the materials that are being taught in curriculum of their kids' schools, owing to the school's invocation of copyright as a basis for getting around state public transparency laws. I first became interested in this issue several years ago with just a nearby mom who was concerned about something that was being taught in her schools, had raised the issue to school board members who were told that sort of thing would never be taught in our schools. And of course, she had images from the textbooks that she wished to share, but when she was when she was getting ready to do so, she was given cease and desist letters and told that if she did so, she would be promulgating copyrighted materials and would face consequences for it. And since then, we've done any number of public records requests, and oftentimes it's not even the companies themselves, it's the schools invoking it on behalf of the companies, saying we can't share with you these materials because they're copyrighted. Now, if that sounds like something that doesn't square easily with the First Amendment, that's because it probably doesn't. Copyright, of course, is a fixture of American law. It's even talked about in the Constitution itself. But copyright has always been in tension with the First Amendment and the public's right to know. Ordinarily, however, copyright and First Amendment never find themselves on a collision course because everybody understands the concept of fair use. And certainly, if you're taking copyrighted materials and seeking to publish it just to generate public awareness of copyrighted materials, especially on something as sensitive as the curriculum debate, then that easily falls within anyone's conception of square use. Nevertheless, that hasn't stopped school districts and their lawyers, who are funded by the taxpayers, of course, all across the country, from routinely invoking copyright as a basis for not delivering materials, such that the public's debate on this topic, this hot topic, could be meaningfully advanced. We obviously think that there's going to be perhaps need to litigate this. Copyright bows to the First Amendment and not the other way around. But it shouldn't get that far because it should be just per se an instance of fair use. In the meantime, however, local policymakers can certainly devise solutions at the state and local level that would ensure that any materials that are being taught in school are widely available to parents, and they're able to publish them. And as long as they're not doing so for profit or any intent to profit, then that's in no way going to violate a copyright. And there's an even simpler solution, which is, of course, school districts and other government entities themselves should never agree to a contract that prohibits them from complying with public records laws on the grounds that it might violate a private company's copyright materials. If anybody's to invoke that, it should be the private company. But the public entity should be far more sensitive to the public's right to know and just not enter into those sorts of contracts in the first place. But we think that that's an important way that we can start having better debates about some of the things that are dividing the nation today.
All right. Thanks, Braden. Next up is Kevin Schmidt.
Thanks, Ryan. And thanks, Braden, and to all the other folks here that are part of the Right on Transparency Coalition that was launched in October. There's 9 organizations there, including some of the folks on this call: National Taxpayers Union, Southeastern Legal, and Better Cities as well. So I'm happy to have you guys here participating in this event. For those that are unaware of the coalition, it's rightontransparency.org. There's 3 model policies there that we launched back in October, but for Sunshine Week this week, we launched our 4th model policy, which is about the small handful of states that don't allow records requests from out-of-state citizens. And there's only 5 of them, and along with a handful of others where it's sort of unclear. The states are Alabama, Arkansas, Delaware, Tennessee, and Virginia. And then in Kentucky, there's a situation where most people out of state aren't allowed unless you're a foreign corporation who has a business interest in Kentucky, or if you're a news media organization. So 40 plus states, if you're not in that state, you're allowed to submit a records request there. We're talking about a small 5 to 6 states where this is still an issue, but it's something that has come up with our coalition, and it's come up with people around the country that are concerned about this. So our model policy basically says states that have this bad policy should fix it. They should allow any person in the country to submit an open records request and get records in that state. And a couple reasons for that. Number one is that transparency is just an unalloyed good. We need transparency in these states, and people have a transparency interest even if they don't live in the state. And there's a couple of examples I cite in the essay. The first one is based on the Supreme Court case in Virginia. And in that case, the plaintiff was actually an ex-resident of Virginia. He used to live there. His ex-wife still lived in the state. He tried to get his child support payments that he was owed. The state agency there stonewalled him for 9 months. And he submitted a records request to sort of investigate the policy and why this was going on and why he wasn't able to get what he was legally owed. But he lost that case because Virginia had a law that said you had to be an in-state citizen. So that's just a concrete case where this is a harmful policy that doesn't really protect people and protect state taxpayers. The other example is sort of a hypothetical. There are people across this country that commute from different state to state or live in border districts. For example, I lived in Washington, D.C. I commuted to Arlington, Virginia. In a hypothetical case there, if my rights were violated, my constitutional rights were violated in Virginia, unless I had an expensive attorney and tried to get discovery, I would have no avenue to get records about the policy, about why my rights were violated, about anything about that, unless I was able to bring a state or federal lawsuit. And so I think that what usually happens when we talk about this is that the biggest complaint, number one, is that in-state folks think they might be subsidizing records requests from out-of-state citizens, but that's just not the case. And I'll wait for Alan to shake his head. But what usually happens is the states and our coalition has a model policy on fees, but out-of-state requesters get charged fees just like in-state requesters. And that should cover the cost of doing that request. And in our experience at AFP Foundation is that we get charged routinely hundreds of dollars for very simple records requests for PDF documents that require no review time at all. Things that should have been on their website that are on websites in other states, but we're getting soaked for $500 for a couple of PDFs, and it's insane. And I guess another couple of reasons here is that most sophisticated requesters, if they're not in that state, they find proxy requesters. They get around the ban anyway. And the last point I want to make here is that adding an extra burden here, it's not only a burden to out-of-state requesters who that no longer have access, it's to in-state folks as well. You have to provide proof of your citizenship either by providing a driver's license or other sort of sensitive personal information that you have to email to the government agency. The agency has to check it if they choose to. So there's no real compelling reason to limit it to in-state citizens. There's a lot of compelling reasons to open it up for everyone. And I'm glad our coalition took this up, and we'll be looking at different model policies as the year goes on. Thank you, Ryan.
Thanks, Kevin. And to echo what you said, many of the folks we have here today on the webinar and who contributed to the development of the new model policy are obviously they're members of that coalition. So check out Right on Transparency to learn more and to review some of the other policies that have come out. The link's right there from Kevin in the chat. Joe, your turn.
Happy Pi Day, everybody. Well, last week, Congress passed half of a federal budget for the current fiscal year, 1,050 pages. Presumably they'll pass the other half in the next couple of weeks, probably another 1,000 pages. What could be more transparent than that, right? This is the budget for the current year that actually began back on October 1st. So if they were doing it right, we should be right now talking about the coming budget. In fact, the president's already proposed his budget for the coming year, even though we haven't finished the budget for the year we're already 5 months into. And this, of course, is not an unusual experience. The federal government's only adopted a budget on time 4 times in the last half century. Put another way, 91% of the time, the federal government is not adopting its budget on time. Instead, every year we get these shutdowns and CRs and reconciliations and omnibuses, all of which are a disservice to transparency and awareness of what is actually in these budgets. this is more than just an arbitrary deadline. I do like arbitrary deadlines, but it's more than just that. Because Congress is always playing catch up, it's always behind the ball. They have no time for prioritization, for tough questioning about programs. And that's frankly what we're missing because of how we've structured this right now. For example, there's over 1,100 federal programs that have expired authorizations, but continue spending money anyways. $250 billion, $250 trillion a year. Some of those lapsed authorizations going back to 1980. That's how long that's the file Congress is on, so to speak. We've got 160 housing programs across 20 agencies, 84 different alternative energy programs, 130 internet access programs, and so forth. With this as the status quo, small wonder that balancing the budget seems so impossible. How do we even begin to fix this? Transparency. Senators Lankford and Hassan, they have a bill pushing for a comprehensive inventory of all current federal programs and their goals. You'd think that exists. It doesn't. They would make it happen. We at NTU are working with people all over the political spectrum to close budget gimmicks and prevent the creation of slush funds to get around the budget process. Senators Paul and Hassan are asking the GAO to identify all duplication in the federal government, both now and going forward. We've successfully pressed House leadership to include dynamic scoring in legislation, so we're not ignoring economic effects, whether they're positive or negative, of proposed bills. And we're also pressing that government loan programs adopt fair value accounting of actual risk like the private sector does, which would save taxpayers billions in future avoided bailouts. All of these ideas are means, they're tools, but the end would be a sane, transparent, working federal budget. These various proposals for an overhauled budget process and the various proposals that are out there for a fiscal commission could make use of all of this information to finally actually identify solutions for our federal budget and our national debt. That's what we're working on.
Thank you, Joe. Before we move on to Alan, to everybody in the audience, if you have questions, please feel free to stick them into the Q&A function so that they're up and ready to go once we finish this round of presentations and any panelist questions. So we invite your participation. With that said, Alan, the floor is yours.
Good afternoon and happy Sunshine Week. Unlike many other symposium essays this year or in the past, mine does not identify a transparency problem per se and argue for change, at least not explicitly. I suspect, Ryan, you might tease something out of me that I've alluded to in an endnote or in our casual discussions. Instead, I thought I'd follow up on a report that another organization completed in 2018 concerning the frequency of federal FOIA lawsuits filed by nonprofits between 2001 and 2018. That organization is called the FOIA Project, and it maintains a very helpful database of FOIA lawsuits. And it found that more than 50% of all federal FOIA lawsuits, I think about 56%, were filed by nonprofits. And interestingly, that the same 4 or 5 organizations appeared on the list of top 10 filers across presidential administrations, regardless of political party. Now, I don't have the resources to identify and track all nonprofits to update that 56% figure that I mentioned. I believe the FOIA Project identified about 650 nonprofit organizations that had filed lawsuits. But I was able, using DOJ data, to compile new top 10 lists for the past 5 years. And I'll just share a couple of findings briefly. Those top 10 lists are in my essay. First, for those familiar with Judicial Watch, it remains the king of the FOIA litigation jungle. across 20 plus years, which is quite impressive. They're not the top filer every year, but across the 20 years, they are the most frequent nonprofit litigator. Second, many of the top 10 litigators from 2001 to 2018 remained top filers over the top 5 years. I think 6 out of the 10 made the most recent top 10 list. And then thirdly, and perhaps especially interesting to this panel and our audience, the list shows that right of center organizations, many of them newly established, have greatly increased their judicial activity since Biden took over in 2021. This follows what happened after Trump won the White House in 2017, notably with American oversight. So I'll end there and look forward to any questions.
Thank you, Alan. Andrew, floor is yours.
Thank you very much, Ryan. I'm Andrew Blackburn with the Mercatus Center at George Mason University. I wanted to start out by thanking our host, the AFP Foundation, for inviting us to speak, and also, kind of getting together a group of liberty-minded individuals to talk about transparency issues. Now, any opinion that I express today is firmly my own and shouldn't be construed as like the official policy of the Mercatus Center. My team focuses on studying regulation and how the growth of the administrative state impacts various aspects of the economy. Now, the main tool that we use for that is something called reg data. And if you're not familiar with reg data, for the past 10 years, we've been quantifying regulatory restrictions at the federal and state level, using the data that we produce in economic studies to understand how regulation affects economic growth, business dynamism, poverty, income inequality, things along those lines. If you're interested in that work or in using the data, all of that's available at quantgov.org. Now, in the process of producing reg data, we gather a tremendous amount of documents. And usually when we run into problems, those are due to technical issues like, running into a poorly formatted website or an outdated website, rather than transparency related issues where the government's trying to conceal something from us. But if that's appropriate, because regulations are kind of the basic rules of the road. They should be just easily accessible to anybody. But when you dig below the surface of just the regulatory code, you run into a couple of troubling trends. And the one that I want to focus on today is something called incorporation by reference. Basically, what this means is that within the text of a regulation, there will be a direct reference to some external document, thus pulling that document into the regulation and making it enforceable by the rule of law. Sometimes this is just referencing another regulation. So states, in a state reg, they'll reference a particular federal rule, and rather than reprint all of that text in the state reg, you can just go look at the other document. But oftentimes, this is referring to documents that are produced by non-governmental entities like trade associations or private standard-setting organizations. Now, we've recently started to try to look into these kind of privately produced standards so that we get kind of the full scope of what's on the books. And we've run into a number of issues, for example, pointing to standards developed by organizations that no longer exist, pointing to specific websites that no longer exist, pointing to addresses where you can get the physical copy of these standards that if you look it up on Google Maps, that building no longer exists. And perhaps most concerningly, almost immediately we ran into paywalls. So to try to ascertain how common that practice was, we went on the website for the National Institute for Standards and Technology, which is one of the largest standard setting organizations out there. They utilize a database that shows all of their standards that are incorporated into the federal code. I've linked that in my essay if you wanted to take a look at that for yourself, but the top line numbers show that they're among the 5,700 or so unique documents that are referenced at least once in the federal code. A whopping 40% of those are behind paywalls. And if you average that out, that's If you average that out, it's about $122 a document on average, but there's a pretty wide variance there. For example, one set of engineering standards would cost you $20,000 to access. And if you wanted to get the entirety of those paywall standards, it costs you a little bit over $250,000, which obviously is concerning for a nonprofits research organization like ourselves. We don't want to pay that much for good data, but clearly we're not the biggest victims here. The biggest victims would be the small businesses that don't have compliance departments that are used to shouldering this type of burden and can't risk a regulatory issue. So now, to be fair to the private standard setters, it does take a lot of work, time, resources, scientists, engineers to develop these standards, and they should expect payment for their intellectual property. It's also probably not reasonable to expect agencies to develop this type of expertise in-house, so it makes sense for them to kind of farm out some of that work to places where the expertise lies. And I'm not even going to, say that the standards that are developed aren't somehow publicly beneficial. Like, I like building standards that are going to prevent the roof of my house from falling in, for example. But none of that kind of goes to the principal kind of point where if these documents are referenced by regulators, then the government can come after you if you don't follow them. So anything that is something that's part of the standard law is something that ought to be publicly available without a paywall. If agencies think that these standards are something that should be required and enforced, then they should figure out how to cover that burden and not put a paywall in front of the general public. So we're going to continue to dive into this particular issue at Mercatus, and I'm looking forward to anybody who's experienced this themselves and the further discussion. Thank you very much.
Thank you, Andrew. And I would just point out, for those of you who do a lot of federal FOIA, incorporation by reference is actually mentioned in the FOIA in subsection A1 with respect to the Federal Register publication requirement. So take a look at it there, and the transparency issue isn't just here, as Andrew, I think, very persuasively makes out. It's not just a burden on regulated entities, but even the interested public who wants to learn about the standards that are applied in a law-like way have difficulty accessing this material. All right, Greg, you're up next.
Thanks, Ryan, and thanks to everybody so far. This has been a fantastically informative panel. I'm president of Better Cities Project, and as you might expect from the name, we spend our time sort of down closer to the dirt compared to some of my colleagues focused on federal privacy issues. And one of the things that I see over and over again, and that we've decided to set our hats toward at BCP, is sort of a perfunctory and performative compliance with requests for transparency by local and state governments, where there'll be either a local government official or activist ask for a higher level of transparency, and after some back and forth, what happens is a dashboard style solution is produced. There are lots of consultants selling these, and you can get the city's budget or get the state's budget or do a deep dive in. It's the public sector generated equivalent of what a lot of center right organizations have done, particularly state based think tanks, developing a public checkbook. What are my public officials being paid? What are the employees being paid? And while that is useful data, I think, and I am encouraging my colleagues to think, that real transparency and open government is a cultural shift as much as a specific policy shift. We can come up with, and we have come up with, all sorts of legislative attempts, ordinance attempts, policy enacted by local manager attempts to encourage greater transparency and openness, and a determined government will consistently figure out ways to get around that as best it can. So part of my work is trying to show governments that it is in their interest. And luckily, the data supports me on that. There was a study done in 2012 called Recovery Act Transparency, Learning from the State's Experience, that looked at how Recovery Act data was actually used. And activists and journalists did use the data. The principal users of the data, as it turns out, were state officials who wanted to see how this money was being used in their state. And that sort of dynamic, I think, is not a fluke, but is something that could be replicated if more people had access to the data. The other thing that aligns solid what I would call pervasive and cultural transparency for government is simply that it generates public support. There's plenty of data showing that a government that is open with its people and that communicates that openness consistently not only gets better input from the public and can make better decisions based on the data being open, but is simply perceived to be doing a good job. And for those of us who have watched the decline of trust in institutions for years and years, that is, that sounds like a very soft policy goal, but I would submit that anything that helps the government itself do a better job by informing its citizens better is an unalloyed good. Thank you.
Thanks, Greg. Liam, AFP Kentucky.
Hey everyone, as Ryan said, my name's Liam Gallagher. I'm the Legislative Director for Americans for Prosperity Kentucky. The essay that I submitted this year was on how open records laws across the country really mimic the principles that allowed us to have this great American experiment that we have today. Most of the people that went before me are much smarter and much more involved on this issue than I am, but to share a quick story about how I got involved, I started college in the fall of 2020 during the COVID-19 pandemic, and quickly utilized open records law, specifically the Kentucky Open Records Act, at my public university, the University of Louisville. A student organization that I was a part of was being punished for violating COVID-19 guidelines. I used open records to realize that only certain student organizations that had certain ideological feelings were being punished while others were not. This caused us to start activating on a due process law to encode due process rights for students at public universities in Kentucky. When we went and as student groups and tried to pass this law, we were able to utilize open records laws to figure out how much the universities were spending against us, hundreds of thousands of dollars against student groups who had no money of their own. Inevitably, we passed the law. I was very thankful that we had the Kentucky Open Records Act. And this year, I was sitting just doing my regular review of bills that had been filed. And I came across House Bill 509, which is a bill in Kentucky that targeted our Open Records Act. And so we really started to activate on this bill. What House Bill 509, when originally filed, did was it basically redefined what an open record was to include only final transactions or final actions and transactions. So everything that I did as a citizen activist on my own before joining Americans for Prosperity would not have been available to me under the new definition of the law. And so we worked as AFP Kentucky with the bill sponsor, with the Kentucky Open Government Coalition, and many others to use public backlash to try and get this bill amended. And inevitably we did. We made it much better. The bill now reads that basically state agencies are required to use state funded email devices. If they don't, employees can be disciplined or fired. And the bill isn't perfect, but it was the public input that came from the backlash of the original bill that allowed us to amend it. And that's where my essay comes in. You know, open records laws and government transparency are truly an American concept. Since our founding in 1776, you know, we're a government that is for and by the people. We're a government that derives its ability to govern from the consent of the governed. And the only way for citizens to stay informed is to have a look in on the decision-making process of government. Thomas Jefferson said it himself. He said, a well-informed citizenry is the best defense against tyranny. And attacks on open records laws across the country, whether it comes at a state or federal level, need to be fought back against. If we don't, if they take away that inside look that citizens have, if they take away the free and open examination of government records, where does that leave us? And that's the question that I tried to answer. Not in a good place. If open records laws are gone, what comes next? It could be our civil liberties. Who knows? And so my essay focused on the fact that citizens need to stay ever aware. If we weren't in Kentucky this year, we would have had a very bad bill that would have gotten rid of basically our Kentucky Open Records Act. And so as we move forward, Americans for Prosperity, I'm sure, and all the organizations on this call will continue to stay aware, but as citizens, we must do so ourselves as well. Thank you.
Thanks, Liam. And then our last panelist presentation from Thomas Kimbrell.
Thanks, Ryan. So I'm going to be talking a little bit about how we are using Pennsylvania's right to know law to educate the public there, the people and policymakers about the impact of some of their healthcare laws. So after the COVID-19 pandemic, a lot of states were assessing their healthcare systems in the aftermath of the public health emergency. Because early on in the emergency, a lot of states found their healthcare systems were overwhelmed, and they found themselves short on beds, short on medical practitioners, and short on equipment. So Pennsylvania's governor at the time issued an emergency order allowing medical professionals licensed in other states to treat patients in Pennsylvania via telehealth. And at the time, telehealth was pretty popular during the pandemic. It was being encouraged. People that didn't have emergency conditions or an urgent situation were being encouraged to seek care via telehealth instead of in person. So when the public health emergency ended, these emergency waivers for out-of-state care providers expired as well. So a lot of patients had established a patient-provider relationship with an out-of-state provider that they were no longer able to access. And our team in Pennsylvania, our AFP team in Pennsylvania was, curious to know how much access did Pennsylvanians lose. For over 2 years, these emergency waivers were in place, allowing out-of-state practitioners to treat Pennsylvanians. So we filed a right to know law request with the Pennsylvania State Department, seeking records regarding the out-of-state practitioners that received waivers. So the governor's order said, in order for these medical professionals to treat Pennsylvanians, all they had to do was email their licensure information to the appropriate medical licensing board in Pennsylvania. So Pennsylvania has 15 medical licensing boards that, there's one for doctors, one for nurses, one for psychologists, speech language pathologists, even veterinarians, dentists. So we're starting to get records back, and those record productions are ongoing, but our initial findings show that there is a large supply of healthcare providers that are willing and able to treat people in Pennsylvania that they no longer have access to. So, for example, in the there were 900 speech language pathologists received emergency waivers, over 600 occupational therapists. Right now, we're getting records from the Board of Psychology, and we're at about 200 that received emergency waivers, but that's just for psychologists whose last names start with the letters N through S, I believe. And then for nurses, there's over 1,000, and that's just for nurses whose last names start with the letters A through C. So you got 3 out of 26 letters in the alphabet there, and there's over 1,000 that received emergency waivers. And we have emails in the records as well where these healthcare providers were mailing or emailing the State Department asking about as the waivers were expiring, they were emailing asking, how can I continue to see my patients in Pennsylvania because the emergency waiver is expiring. So there's clearly a latent supply of healthcare that that Pennsylvanians would have access to, if not for these out of date licensing laws. And so that is a project that we are working on and through Pennsylvania's right to know law.
Great, thanks, Thomas. All right, now that we've all had a chance to present, before we entertain any questions from the audience, and I had some questions as well, I'd like to take a moment for you panelists to ask each other questions, or even if it's not a question, to comment on what's been stated so far. And I know, Alan, that you had 2 questions for Kevin and Braden, I think. If you wanted to raise those, now is the time.
Okay, thank you very much. I enjoyed all the presentations. For Kevin, I was curious whether the coalition would accept in its model policy as an alternative to a residence of getting rid of the residency requirement, simply higher FOIA fees for out-of-state residents, much like out-of-state students have to pay, in many cases, higher tuition than in-state residents.
Sure. I mean, I think again, that's sort of like a solution in search of a problem there. There's no evidence that I've seen that out-of-state requesters in the 40 states that allow them are the ones driving huge budget shortfalls on all these agencies by submitting requests. In fact, most of the complaints about vexatious requesters are people getting too many requests and they're costing agencies or localities too much money are local people. So I just don't see any particular basis for it. Would it be better than a ban on outside folks? Yeah, I mean, I suppose so, but I just don't see a real justification for that sort of difference in terms of a fee structure.
Any other thoughts there? Alan, any retort?
No, I think that's a reasonable response. My question for Braden was on the copyright issue. I was curious whether schools ever offer in-person inspection of records, but prohibiting copies and photographs and the like, and whether you're willing to accept that as a compromise.
Well, I have seen that. I think that's actually, I mean, it seems less bad, but it's actually probably more incoherent. If you can see it, you should be able to publicize it. And obviously, you're depriving the information of its value if the person can't take what she sees and then disseminate it to others. Particularly in the curriculum debate, there's this fundamental issue of people saying, well, what you think is happening isn't really happening. So being able to show images in books or teaching lessons is absolutely essential. It's not enough that the person just go there, write it down, and then describe it later on, because that person's not going to be believed. And of course, if the concern is seeing something that's copyrighted, it actually shouldn't matter if the person is duplicating it or not. I mean, if the person is seeing it and it's a trade secret and they can describe it, well, Coke's not going to let you walk in and see the secret magic formula for Coke, write down the recipe, and then walk out and describe it to anybody. I mean, that's a legitimate concern about trademark. So I think it only underscores the groundlessness which that is brought up. The Supreme Court has said that the First Amendment doesn't protect just speech; it protects the promotion of speech and the creation of speech. So if you're limiting someone's ability to just take a fact and then disseminate it, then that is inherently a burden on speech, and it should be recognized as such.
Braden, I have a question for you. And then I think Kevin does as well. So the copyright excuse for not disclosing is a nice legal technicality. To what I could have sworn I've heard stories in the news. To what extent have there been teachers unions, public school teacher unions involved, or teachers independent of the union, pushing back like on academic freedom grounds or something like that, and objecting to public records requests for curricular materials that they might be using in the classroom?
Yeah, there's some federal laws that speak to like lesson plans or teachers' notes, and those lines are drawn. That's a little bit different than a teacher who just wants to see, or a parent who wants to see something that was taught to their kid, a survey they had to take, an image in a book. Those are the kind of things that are just going straight to the heart of what people are arguing about in the public school setting. And I think we could have a much better debate if people could just arbitrate the facts neutrally without having the facts constrained based on these contrived notions of copyright law, which should operate as no bar.
Kevin, I think you had a question too, right?
Yeah, I just wanted to go back to, so I thought what you said was interesting. So there are school districts, they want to use a textbook. Within that contract to use that textbook, there is a clause in there that says the school district cannot, by the contract there, give out anything in that textbook in response to a records request. Is that
right? An interesting aspect of it is that the copyright doesn't belong to the school at all. The copyright belongs to the publisher. So it's particularly odd that you would see the government, who's really a third party, jumping up to assert the copyright on behalf of the private company. But I'm given to understand that that is in no small part because they're agreeing to that in contract. They'll protect the copyright of any materials, and then they believe, either correctly or incorrectly, that means that they don't have to turn over anything that they think the publisher wouldn't want to see the light of day, even while they're doing what Alan said, where they might invite the parent in to come in and see it, but they just can't publish it. But as I maintain, I think that's an even more incoherent standard. And to broaden it out, I know any number of places that have you can see it, but you can't copy it policies. And I think that if I hadn't written on copyright, I probably would have written on that. It's a niche issue, but I do think it's meaningfully important. I don't know why any governmental entity would have a legitimate reason to say you can see this thing, but you can't duplicate it and show it to anybody. I can only think of bad reasons why that would be a policy.
So we had a question from Greg to everybody. If what's something in your experience that has been a very notable development? You can speak to the federal issue, to the federal level, but since we're all in different states, maybe the state context would be more interesting. What's a notable development, for the better or for the worse, that you'd like to highlight in the transparency space?
I'll answer my own question partially. And this is I don't think made the cut in my essay because I was trying to keep things short. But one of the things that fundamentally affects the government's transparency relationship with the public is the deteriorating state of journalism. And there's a biannual survey of Freedom of Information Acts put out by, I believe, the National Freedom of Information Center. And in 2020, for the first time, the number of requests from the public outperformed the number of requests from the media. And that trend, as far as I know, has continued since that time. There are fewer reporters who are covering more territory. And in an age where journalism relies on clicks, they are much more apt to chase clickbaity stories than things that are important but difficult to understand. And so within that survey from 2020, there was an increase in the number of, not just in the number of public requests, but respondents reported seeing an increase in pushback and incorrect interpretations of the law. Again, the data behind that trend is now 4 years in the rearview mirror, but I think it's a development that all of us should be aware of. Historically, not to put too fine a point on it, but wonks and litigators like us were not the main vanguard of trying to get the government to be transparent. It was the journalism industrial complex, and that complex is largely deteriorating.
Any other?
But that's not good news. I would like somebody to talk about a win.
One of the reforms that we saw in Kentucky for on the negative side, it wasn't in the last year, but back in 2021, the legislature exempted themselves from open records and made themselves the final arbiter of what is an open record for the legislature. They also, this is one of the first sessions we've gone through where they no longer have to pre-file their bills. And so if session starts on January 2nd, we don't see the bills until they are filed by the legislator. And it can be as quick as 3 days from the time that a bill is filed to the time that it's passed through both houses, which makes it extremely difficult if they're really keen on fast tracking something in order for us or citizens alike to actually have a say on it. If they file it on Monday, it can be passed by Wednesday through both houses. So that's something that we're facing here in Kentucky. And I think the bill that was filed this year is kind of the exact same thing, except opposed to doing it for the legislature, they're doing it for state agencies.
I think Kevin is generally right that there's been a lot of defense at the state level, but there's been a lot of success in that defense. So I can think back to September in Arkansas. There was a successful defeat of a bill that would have significantly changed how exemptions worked, introduced deliberative process privilege at the state level. I mean, that would have affected a huge way in the way the FOIA works down there in Arkansas. So there was a great successful defense there of the law as it stands. Any other panelist questions?
Let me add on that real quick is that the problem with these bad ideas on bad changes to state records law is that they're kind of contagious. So one of the big pushes now, and some that Braden flagged for what's happening in Tennessee, is that they're trying to exempt certain whole categories of records from whether it's economic development agencies or in this case, it was the Department of Tourism, to basically say, you know, these records that were once public records are no longer public records. And then after a certain period of time, they might be able to be, but they also might get deleted. And so things like that, those are ideas for states where they say, if you want this economic development, if you want a Super Bowl in your major city, you need to pass a law like this. And it gives a lot of leverage to folks on the other side that are pushing for those sorts of corporate welfare and subsidies like that to say, you know, we went to this state because they had these policies. So if you copy those, we're all going to be more likely to come to your state. And that's something that we see elsewhere.
I think the New York Times just had a piece on legislation in New Jersey that would follow that exact trend, Kevin, of creating whole exclusions and carve outs for certain types of records. There's been, Liam's example of 509, and I know there's use of personal devices, intra-court decisions dealing with what happens when you have government officials who use private email and so forth for government business. To what extent can you still get those materials? Obviously, we have it's pretty well established at the federal level that you can still get them, but that's not always the case in the states. Alan.
I was just going to quickly add that to Kevin's point, when Florida exempted the governor's travel records, controversially, I think that's the sort of thing that other states could adopt as well. It certainly made national headlines.
Ryan, you're freezing up a little bit.
Yeah, I got. Reminds me, Alan, your comment there. It also seems to be the case a few states have in the recent past tried to reevaluate to what extent non-executive branch records should remain subject to a disclosure. So I think North Carolina was a big one, and I think there they actually were successful in limiting access to legislative branch records. So that's an unfortunate development there. I would be curious to whether, well, so two broad topics that I would throw out there that I would be interested to know what you all think about. First, which is somewhat related to one of the questions that's been raised by an audience member in terms of effective records management, at least at the federal level, since the introduction of the capstone program and just the general shift to electronic records. I mean, the amount of material that is out there is tremendous. And there has been a lot of talk. And in fact, I think as we speak, there is another panel that OGIS is hosting that I think is addressing this, if I recall. And even if it's not, it's been discussed recently, which is artificial intelligence and other technological innovation improve FOIA processing. And there have been some who have raised concerns about that. I've mostly heard concerns from FOIA practitioners, litigators on the requester side about how we should think twice about wholeheartedly embracing artificial intelligence when it comes to records management. FOIA, not just records management. So if you have thoughts on that, I'd be interested. And then also, I think in terms of your ideas for improving things, if there's something that one reform that you could pass through, one that kind of struck me as having been implicated in a couple of the essays, and in particular, Joe, in your piece, is just more robust, proactive disclosure. So a lot of the budgetary dynamic scoring information, it would be helpful. I also think of Executive Order 13-1 that the Trump administration had implemented, which required the cataloging and proactive disclosure of sub-regulatory guidance. That was rescinded, and a lot of agencies, I heard, they were ordered to disable those databases. Any thoughts also on proactive disclosure and how that might be a way to improve transparency?
Yeah, it really is the name of the game in budgets, because if the agencies aren't producing estimates of cost burdens or regulatory burdens, such as what you just mentioned, the OIRA estimates of regulatory burden from sub-regulatory burden, they're absolutely vital to be able to talk intelligently about whether these are good or bad. Because, proponents of some proposal, some regulatory or sub-regulatory proposal, they'll always talk about how the benefits are great. And if you don't have any information on cost, you can't counter that. So, if it's going to impose a huge burden on every business in the country, then it probably dwarfs the whatever asserted benefits that there are. And we need to be able to have that information. So, setting up these processes in order to make sure those are produced is really important. There are some entities out there. Tax Foundation does revenue estimates. The Penn Wharton Budget Center does some stuff. Tax Policy Center does some stuff. But ultimately, nothing's going to replace the Congressional Budget Office and the Office of Management and Budget in putting this stuff out there. So it's really important that congressional rules be modified in order to require this be produced and produced early enough to matter.
I'll jump in on the AI point is if you use one of the language models, it actually drafts a fairly decent FOIA request. Not as good as anyone can do on this call. I just want to make that very clear. Our jobs are secure. But on the other side, at the agency side, I could see there could be some potential uses for AI there. I can imagine it'd be able to search records fairly easily. It's going to struggle with the discretionary exemptions like B5. And my worry there is that it's going to be even more overbroad than they already are with some of these discretionary exemptions. So I do worry about that. I think it could probably save some time with finding personal information, cell phone numbers, and stuff like that. That you'd have to go line by line and really sort of redact. But so there's a mixed bag there. I think if it's used right, it could be helpful for both sides. But I do have my worries that it might be used for ill.
Yeah, my thought there, and this year we don't have. Oh, sorry, just real quick, Greg. This year we don't have Jason Barron here, who's been doing the research on AI being used for Exemption 5 deliberative process withholdings to kind of design a way. That's the sort of place where I'm really concerned, where we can see, an agency that says we have an algorithm that has been proven to successfully redact deliberative material 99.9% of the time. And then they're going to say that in an agency declaration, and there's not going to be much a requester can do to defeat the privilege, to defeat the exemption claim. But it's a very interesting area. Sorry, Greg, I cut you off there.
No, that's fine. I am very interested in seeing one or more states adopt very, very declarative thou shalt transparency standards and open government standards that go beyond how meetings are conducted and go beyond how efficiently FOIA requests are made, and pushing those standards down to their counties and cities. I'm looking for an expansion of state direction in that area. And although I am any public sector budget that is reduced is good kind of guy, I would be willing to entertain state grants to more to smaller cities and more rural local governments to implement that, because it's a huge need. And the number one pushback across the country when you try and do something like this is, okay, you've dumped this huge unfunded mandate into our laps. The challenge that this type of legislation faces is that you need a genuine 5-alarm corruption or lack of transparency fire in a municipality or in a county, in a state, before you can usually get state legislators on board with something like this.
Great. Do we have any other thoughts or questions? Do we have any other questions from the audience? What we'll do is, if we don't have any questions, if there's any final thought you'd like to share, please go ahead and do so. do so now.
I have a quick question for Andrew, because I thought it was very interesting on the federal government level. I assume there's the same issue at the state level. I just wanted to know if it, and obviously that's harder to, I'm sure that's harder to investigate with the 50 states, and I just wanted to get your sort of top level view on how big of a problem that is in the states.
Yeah, so that is also, I mean, very clearly a problem in the States. It's harder to get like precise numbers on that, but talking about incorporation by reference and also the potential use of AI, this isn't like directly a transparency issue, which is why I haven't brought it up before, but like Virginia, for example, has an executive directive that was followed up by an executive order about AI generally. Most of the order was related to like how we, should regulate AI, the marketplace, but one particular component of that was related to how AI could be used in governance. And we had a couple of conversations with their Department of Housing and Community Development kind of earlier on in this process about how they could use AI to read the International Building Code, which a huge portion of which is incorporated into the Virginia Code by reference. And it's a very similar process throughout the states. And just in several of those conversations, it became clear that just that bulk of incorporated documents leads to like a lot of confusion. There's a lot of potential for kind of overlap or contradictory regulations that come from the building code that's continuously developed over the years. They have an arbitration board where if some sort of conflict gets all the way up to that particular arbitration board, even it's just kind of a flip a coin on the choice just because of how confusing some of those ought to be basic standard rules and regulations are phrased and how they can be just interpreted differently. So I think maybe less so as like a direct transparency or like FOIA related issue, but more just on a good governance issue. Something like AI can be used to kind of sort through stuff that doesn't necessarily have privacy concerns and just help different jurisdictions at the federal, state, local level more efficiently sort through those things and not cause an issue where there's going to be confusion or additional burden or opacity for business owners or individuals.
And one brief follow-up on a different part, what you spoke about, how there was an incorporation bar. Sometimes you'd run it down and you said that there was an address and it didn't work, or a phone number that was disconnected. Does that mean you're just out of luck at that point?
So oftentimes, and again, we have to kind of be a little bit more thorough about this, but oftentimes like smaller standard setting organizations will get absorbed into something like the National Institute for Standards and Technology. But if it's an older regulation, then that might very well be the case, right? Where it's just perhaps there's a form of this in some other way, but like if you're just looking at the plain text of a regulation and trying to track something in particular down, you're kind of running into a dead end. And unless you are somebody in the marketplace that has a very specific niche understanding of where that is, it's not gonna be any clearer for you.
They probably have a paper copy stored in a physical reading room that nobody knows where it is anymore.
You can actually, get access to a fair amount of this through the government publishing office if you set an appointment and go in and promise not to take pictures of the standards that are in there, and who knows whether or not those are up to date as well. So it's very, it's problematic, let's say.
Indeed. All right. Well, I want to thank all of you for participating in the symposium this year, both in writing the essay and in giving us your time here on the webinar. And I want to thank the attendees this year. I hope you've found this all very edifying. If any of you in the audience haven't had a chance to read all of the essays yet, I would encourage you to do so. The material it's really good, and I'm so grateful that we've been able to demonstrate that liberty-minded folks take transparency very seriously, and open government is a vital part of a healthy political community. So with that, thank you all, and happy Pi Day and happy Sunshine Week.
Thank you, Ryan.